This is case number 24CR41416, the State of Ohio versus Aaron Jones. Mr. Jones is present before the court with counsel, Ms. Morton. Mr. Arnold's here on behalf of the State of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before. It's not
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you won't.
Man, it ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and you never know how good you might be.
Alright, guys, buckle up, because this is where confidence meets the real world. The defendant boldly insists on representing himself, clearly believing intelligence alone is enough. The judge stays calm and methodical, asking simple but precise questions that quietly expose how unprepared this man actually is. There's no argument here, just a slow dismantling of false confidence. This moment sets the tone. Belief doesn't replace knowledge in a courtroom.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry? Cool. It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I got to do. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No.
Here, the defendant treats prison time like a distant possibility instead of a real outcome. The judge responds by grounding the conversation in reality, carefully explaining what's actually at stake. There's no threat, no emotion, just facts. You can see the gap widening between fantasy and consequence. The defendant still believes he's in control, while the judge is already operating several steps ahead.
Just want to represent myself. Man, I can't go any worse than it might be about to go. It's only 3 years, man. That's all I got.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Is he in shackles? Okay, there's the other problem. Because you are in custody, you have shackles on. You want you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so, I mean, that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but...
This part is quiet but extremely important. The judge explains what waiving counsel truly means, including how jury perception and restraints can affect a case. The defendant agrees to everything without fully understanding any of it. This is the danger zone, when someone consents on the record while missing the implications. From this point on, responsibility begins shifting entirely onto the defendant.
A little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is this of the alleged victim and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
That's correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any? You're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state. Right. You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to...
Now the judge tests preparedness, not to humiliate, but to clarify reality. Questions about defenses and legal strategy reveal there is no real plan, only confidence. The answers are vague, incomplete, and exposed almost instantly. What becomes clear is that self-representation here isn't a strategy, it's a gamble. The courtroom sees the imbalance clearly, even if the defendant doesn't.
I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that? Mitigating circumstances are? Again, that's another reason why you need to have...
3 years, Mom.
I'm sorry?
3 years. That's nothing.
Let me tell you something. When I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
With the jury trial, so you keep on saying it's only 3 years, that's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
That's your opinion.
It is my opinion, and I'm strongly advising you against it. But do you understand that in my opinion, if you represent yourself, it will be detrimental to your case?
This section focuses on courtroom conduct. The judge draws firm boundaries, explaining how behavior in front of a jury can shape everything. This isn't about authority, it's about damage control. One emotional slip can undo an entire case. The judge is warning him without sugarcoating, making it clear that discipline matters just as much as arguments in court.
Everybody's entitled to their opinion.
Okay, but you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
You will be required by law to follow the Ohio evidence and the Ohio rules of criminal procedure. Do you understand that?
Yes, sir.
Your lack of knowledge of the evidentiary and procedural rules will not prevent this court from enforcing those rules. Do you understand that?
Yes, sir.
You would understand that your lack of knowledge regarding the rules of evidence and the rules of procedure will result in you waiving the review of those issues on appeal. You understand that?
Yes, sir.
If you have any difficulty in presenting a defense on your own behalf, any difficulty in complying with the procedural rules or the rules of evidence, the court cannot assist you in the presentation of your case in any way. Do you understand that?
Yes, sir.
You understand that the state of Ohio will be represented by an experienced trial. You understand that your right to represent yourself is not a license to abuse the dignity of this courtroom, and thus, if any disruptions during the trial occur, your right of self-representation may be vacated by me. Do you understand that?
Yes, sir.
If you choose to represent yourself when you're convicted, you cannot complain about the quality of your own defense, and it will be basically a waiver of your right to appeal the ineffective assistance of counsel. Do you understand that?
Yes, sir.
Do you suffer from any physical or mental disease or disability?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Here, the judge carefully explains evidentiary rules and the limits of appeals. Mistakes made now may never be fixed later. The defendant agrees repeatedly, but it's obvious the understanding is shallow. This moment highlights a dangerous illusion, thinking acknowledgement equals comprehension. The legal system doesn't protect people from what they fail to understand after being warned.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Has anyone threatened you or forced you in any way to waive your right to counsel?
No, sir.
To counsel.
No, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
The dumpster fire, but you're not going to believe what he complains about next.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The deputies and the transport officers are in charge of your security of this.
How am I supposed to use the bathroom in cuffs? How am I supposed to be able to wipe myself in cuffs?
Right.
The officer refused to move the cuffs when I was locked in the cell. I need to use the bathroom before we get started, sir.
Rhodes?
Yes, sir.
What's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I used the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that
tension surfaces when the defendant disrupts proceedings over a minor issue. The judge immediately restores order without raising his voice. This moment reinforces authority through control, not aggression. The courtroom isn't flexible, and attempts to redirect attention don't work here. Power is clearly established, and the structure of the system reasserts itself.
you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After the presentation of the witnesses by the state and by your arguments, each side will have a few minutes to wrap up their case and present their argument to the jury. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now, I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your counsel table. Now, you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney.
The judge now addresses courtroom security and restraints, placing everything clearly on the record. This isn't punishment, it's procedure. Every word is deliberate, removing emotion from the decision. The explanation protects the process, not the ego of the court. It's a reminder that judges act on responsibility and risk assessment, not personal feelings.
And that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court?
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
All right. And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain. Why don't we do this? Mr. Jones? Let's allow Ms. Martin.
This is the final off-ramp. The judge gives the defendant one last opportunity to accept legal counsel, explaining that the decision is irreversible. The tone is calm but decisive. This is procedural mercy, offered once clearly and fairly. After this moment, there's no blaming the system for what follows.
All of the elements of granting that waiver, do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the form in front of you.
What's the date?
All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
Oh, I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please. Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was
okay,
the whole purpose of
she's
that.
not. She's
still here and attached to my case. That's the
she's
whole
removing
purpose.
herself.
I'm removing her. Was for that. Was for me to be able to represent myself.
You will be. Sign the form. Read it.
Was already signed.
All right, read. I'm sorry, I misspoke.
You see, my signature was on that sheet. You already seen it was there. What are you talking about?
Mr. Jones, read the form. You said you
I already
didn't read
signed it, man. It's cool. Go ahead.
Are you able to read and write?
Sometimes. Depends on how many pictures are on.
Now that I believe.
You done?
I ain't reading. I already signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready?
Ms. Martin is standing by counsel.
Mr. Jones, I'm going to tell you one... Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her, was to represent myself, because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her was based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
This is where everything becomes final. The defendant hesitates, switches positions, then commits again to self-representation. The judge formally accepts the waiver, ensuring the record is airtight. There's no drama, only closure. From here on, every outcome belongs to the defendant alone. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.